Good morning. The first case before us is State of Ohio v. Justin Lee Hensley. Each party will have up to 15 minutes. The appellant may reserve 5 minutes for rebuttal. If you do plan to reserve time, please let me know as I'll be keeping track of the time. The arguments are being recorded, so please keep your voices up, remain behind the podium. You should not use the names of children or minors or victims during your argument. You can refer to those folks with their initials or general terms. The judges have read your briefs and are ready to proceed when you are. And at this time, I ask the appellant, would you like to reserve time for rebuttal?
I would reserve 5 minutes, Your Honor.
Okay, very well, then you may proceed.
And I wanted to verify this is the correct podium.
Yes.
Because we've got to switch it up in the
Yes.
recent times, so.
I believe we have cleared this podium
Good.
for use now. Thank you.
Well, good morning, Judges Giovanna Bremke here on behalf of Mr. Justin Hensley. The facts of this case are pretty simple, but I will briefly go through them. In May of 2020, Mr. Hensley pled via Zoom to the charges in the indictment, and he received a promise that he would, if he completed 4 things, then he would receive a 3-year prison sentence. Those 4 things were 1, go for his PSI, 2, complete treatment, 3, voluntarily show up at the sentencing hearing, and 4, not to pick up any new cases. If he did those things, again, he was promised 3 years. Ultimately, on July 10th of 2020, he did all 4 of those things. He had went for his PSI and showed up to the court, and he's having been satisfied that he did these things, the court gave him his 3-year sentence. But the court did not file the sentencing entry. He gave him a report date of August 14th, which is about a little over a month. The record reflects that my client, this is on transcript page 63, my client indicated that he did try to show up on that report date, but it was a weekend date, and at the time the clerks were closed, and since there was no sentencing entry, the jail sort of turned him away, saying they didn't have any ability to take him into the jail at that time. Lo and behold, he's at his house the next day before the court opens on Monday, and he is picked up on a new case.
Counsel, I was just wondering when I was reading this, we seem so far away. Can you hear me okay?
Yes.
Okay, good. I was just wondering when I was reading this, is there anything in the record other than his statements to the court that he reported to the jail and they wouldn't accept him?
So I will tell you that there was, my recollection is there was a brief conversation between the court and the court's bailiff trying to verify that. I do not know whether there was nothing proffered as far as any testimony from any jail officials or anything of that nature, but there was a brief discussion, and I don't know if the court and the bailiff were able to resolve that, and if they did, it was on the record. He was brought back for sentencing shortly after that and was given three times the amount, 8 to 12 years, arguably over 3 times. I presented 4 assignments of error. The first assignment of error is that the court erred in recalling the case for sentencing after he had already been sentenced. This is pursuant to Revised Code 2929.11a, which talks about the court guiding, the court's guidance in regards to the overriding principles of felony sentencing.
What journal entry are you pointing to that he was specifically sentenced in a journal entry, not just what was said at court?
So you're correct, Judge Stevenson. It appears there was an entry that was produced, because there is this discussion about filing that entry and whether it was filed, and that was the issue with reporting to the jail, of course. But I believe the record will reflect that probably was not docketed, that the subsequent August 28th, 2020 sentencing entry, which is the one before you, is the one that was docketed.
Was any journal entry talking at all about I'll call it the first sentencing hearing sometime in July? Was there any journal entry that said anything about that? what would happen?
As far as if he didn't report,
Right.
I'm not aware if there is one.
The criminal offenses he was charged with sometime in August, I think those came out. When were those charges filed? Were they filed before he was to report to jail or after he was reported to jail? So he gets his 3-year sentence, he ends up not, there's argument about whether he reports to jail or not, but there's also new charges that he gets shortly after the 14th when he was supposed to report to.
Correct, and
Were those, did those occur before the 14th or after, do we know?
I do not know, but I can tell you, the record does reflect it, because I went back last night and looked at the transcript, that my client did say he was sitting at home, so it's not as if, I know that the day that he was, it wasn't one of these situations where he was, you know, let's say pulled over with drugs and cuffed right then and charged.
Okay.
It wasn't that, it was, he was arrested while at home, not while in the commission of any kind of offense.
Okay.
And to your point about not having that entry, there is a note in the court's entry, what you'll see, and there's 2 case numbers here, this kind of goes to my 4th assignment of error. And the 4th assignment of error is the fact that we have these 2 case numbers, and the reason for that is because it was Mr. Hensley's intention, and the record reflects this, to appeal this sentence. But the court had instructed him, if you want appellate counsel and you want to appeal this, you have to write me and tell me why you want appellate counsel. Which I think is a little unusual, because in the time that it would have taken him to write and send to the judge, his appellate clock would be running. He eventually does write the judge, and the judge considers that a post-conviction motion. So you actually have 2 case numbers, and one of them is this subsequent, what the court deemed as a post-conviction entry, and the other one is a delayed appeal on the actual sentencing itself. So the 4th assignment of error, and they've been consolidated for your purposes, the 4th assignment of error kind of brings that together, asking you to consider the actual underlying sentence as opposed to considering this post-conviction. And the judge labels it a post-conviction motion, but ultimately in that letter, my client is asking for appellate counsel, and my brief outlines what that letter says.
Counsel?
Yes.
Were there 2, I was very confused when I was reading this, because the state seems to say there's just one letter of motion, whatever you want to call it, that asks for counsel as well as for post-conviction relief. You seem to say in your brief, and maybe I read it wrong, but you seem to say in your brief that there was a first letter, and maybe that wasn't docketed because it was just a letter, and then the court waited for an extended period of time before ruling on it, and he filed another motion.
I think that that's accurate, and I think the judges, if that's what I indicated, it's likely coming from that judge's entry. It's pretty lengthy, and it outlines those letters that he received. And now that you're reminding me, I believe what it did say was that the court indicated they received a letter, but it wasn't docketed at the time or something of that nature. But all of the correspondence was asking for appellate counsel. I don't believe my client was, he makes reference to post-conviction, I think he says appellate or post-conviction counsel, but he doesn't make any post-conviction arguments to make a post-conviction brief.
How is this harmful or prejudicial to your client? Because he did get an appeal, and he did get appellate counsel.
Well, I think it's more procedural. At the time, I had only, at the time I was appointed, it was within 30 days of that second entry denying what the judge deems as the post-conviction, but I'm really attempting to argue a delayed appeal on the underlying sentence. So we consolidated it for these purposes, and I think it's more procedural, that ultimately what I'm asking you to do is to address the underlying sentencing issues because my client wasn't appointed appellate counsel in time. And you can see from his letters, he's not the most educated individual to know how to seek out the assistance that he needed. I'm probably coming short on time, but my other assignments of error deal with the weighing of these sentencing factors. So Assignment of error 2 is that the court failed to balance the seriousness and recidivism factors pursuant to Revised Code 292912D and 292912E. In here, we acknowledge that the standard is a high standard here. But in order for this court to modify a sentence. But it's clear, and it's clear in convincing evidence, it's clear from the record that the court didn't consider these factors. And I think it's important to note that these new charges would and should be addressed in that case, not as an additional sentencing in this case. Also, the court was never considering giving Mr. Hensley a community control sanction. So there was kind of some talk about the fact that he left treatment early, but the court had already found at that point that prison was what was necessary to rehabilitate Mr. Hensley. I'm coming from the time. Okay, I'm cutting to it a little bit, but the court had already found that this prison term was necessary to rehabilitate him, so punishing him for not completing treatment when treatment was what was not, the court had already determined that treatment would not rehabilitate him is inconsistent with the weighing of the factors. Because again, those are weighing whether rehabilitation outside of the prison setting would be appropriate. So I think it's clear from the record. There's also this issue of violation of 5th and 14th Amendment pursuant to Criminal Law 11C, and one of my favorite arguments, sentencing by ambush. Justice Donnelly, of course, you're probably familiar with his idea of sentencing by ambush. And I would submit to you this is even worse than sentencing by ambush because in a sentencing by ambush, the defendant is not cognizant of any kind of indication of what the court or what it will sentence the defendant or what the state will argue to be the sentence. But in this case, there was certainly an inducement to plea with the promise of a 3-year sentence. And the court involves themselves in that conversation along with these 4 factors and agrees at that first hearing that the 4 factors were met because he imposed the 3-year sentence. So I would say this is even worse than a sentencing by ambush. It's really a plea by ambush because he was, given an indication of what the sentence would be. He did what he needed to do on his end and ultimately was sentenced to 3 times the amount. I will reserve the rest of my time.
Thank you. You will have 3 minutes and 22 seconds.
Thank you.
Ms. Valentino. You may proceed.
Thank you, Judge. Good morning. May it please the court. My name is Rick Raley. I'm appearing today on behalf of Lorain County Prosecutor J.D. Tomlinson and the state of Ohio. And I'll just dive into the substance of these legal arguments here because I believe it's pretty clear that the judgment entry of the trial court can confirm. The trial court had full authority to issue its final sentencing entry in August because there had not been a prior sentencing entry that provided what the sentence was. Until that final entry is issued, the trial court has full authority to issue a sentence that complies with law. And that's controlling case law from this court. Overstreet and other courts have held the same. And, I just do want to address these representations that there was a promise made about the sentence to be received in this case. The trial judge was very clear that he was not making promises. He said what his inclination was at the initial plea hearing. He also gave various warnings to the defendant at the July sentencing hearing about an additional 30 days extension for his report date. And there was all kinds of opportunity for him to understand, the defendant to understand what was going on. So this is not a plea by ambush, it is not a sentence by ambush.
Counsel, I just want to clarify the issues a little bit. So when the court first indicated that he would be willing to consider the 3-year sentence, he had the 4 conditions on it.
Correct.
And it's my understanding that basically everybody agreed that the defendant did meet these 4 conditions, and he was sentenced to 3 years, but the court just held the matter, the judgment entry, because the defendant wanted the court to allow him to go to treatment.
Correct. Judge, I will say at that July hearing, the trial judge says, I am going to hold this and I will give you the report date and you can go to treatment. But again, only if you show up on time and if you do not pick up new charges. And he did not comply with those 2 requirements.
But there's go ahead.
No, I was just going to say, the only thing I want to follow up real quick with is I just want to make sure we're narrowing the issues to what's before us.
Right.
So really what's before us though is not the original, did he comply, but the second time when the judge says, I'll hold this and not file it, but here are 2 more conditions you have to reach, and I know that you have to reach, or meet, I should say. So the court told him at that point, you may get a lot more if you don't.
That's correct, I would say that is.
Okay, so we're really here today about those 2 additional conditions that were put on him after the initial sentencing, oral sentencing.
I would agree with you, Judge Carter.
And then the court, after that July sentencing date, July 10, puts on order journal entry, like I see from one of your briefs on July 14, saying basically that in the last sentence, at which time this court will then file the sentence entry imposed at the time of sentencing. It makes no condition on that so long as he doesn't commit new offenses and shows up. So there's no condition, it seems to me, to be saying, I'm going to give him the sentence on that day.
So that is true, that what he said orally about these conditions was not generalized, it wasn't at the prior hearing either. However, that doesn't affect his authority to then issue a different sentence, because that's clear from Overstreet. And I would just mention on the 4th assignment of error about the post-conviction issues, the letter that is filed with the court refers to infringement of rights. There's plenty of case law from this court saying that trial courts can recast irregular motions to judge them by the standards that apply. That was appropriately done by the judge on that issue.
Is there just one letter? There was some, Judge Carter's question, was there more than one letter? Was there just one letter sent to the court?
I will say all I reviewed was one letter. I do not know if there were more.
There was just one journalized or docketed, I should say.
That's what I recall. That's all I remember seeing as well. If there are no further questions, I'd ask that you affirm the trial court's judgment. Thank you.
Do you, just briefly, sorry. From the record, there was also a question about, does the record show anything other than the defendant's statement showing I was there on the 14th of August and I tried to check in a jail and they would not let me? Is there anything else in the record that establishes that?
That's all my knowledge is, and I also can't speak to the other new charges. I think it's true that you picked up new charges, so I can't tell you the timeline on those new charges, just that they existed after the July hearing.
Thank you.
Thank you.
Thank you, counsel. Ms. Bernke, you have 3 minutes and 20 seconds.
Yes, Your Honor, and I'll make it brief. One of the things I wanted to touch on is the fact that the principles and purposes of sentencing are to be commiserate with the offense. So part of my argument here is that, you know, what happened after the sentence is not commiserate with what happened, you know, to punish Mr. Hensley for the underlying offense. So Judge Carr mentioned these 2 additional things, but again, completing treatment is not something that would be necessary to rehabilitate him, number 1. And also, the judge didn't deem it necessary to punish him for the offense that he complete treatment. And as far as him not reporting, again, there's assertion that he did attempt to report. So I would ask that you vacate the judgment and reverse it so that he can get his 3 years as he had been promised. Thank you.
Thank you. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of that decision to you on the day that it is released, and it will also be posted on the Ohio Supreme